So it looks like we've started to have people join in sporadically. Great. Hi, everyone. I'm Tyler Stokes from ISSS. We'll get started here pretty soon. I think we have about 45 attendees today, so I'm just going to give everyone a few minutes to join up with us. And then I'll introduce our speaker and we'll get going. Thanks for coming in today. All right, it seems like we've had a decent amount of people already join. So, hey everybody, once again, I'm Tyler Stokes. I'm an International Services Specialist from International Student and Scholar Services, and today we are having our second Immigration Options After Graduation webinar for international students and scholars today for 2020 in the fall. Today, our speaker is immigration attorney Kristin Knudson from Knudson & Associates. She represents business and individuals in their immigration matters. Kristin started her career in immigration law at Safe House Denver, coordinating its immigration program to help immigrant victims of domestic violence. She represented asylum seekers fleeing torture and persecution in their home countries. Kristin then gained valuable experience in federal litigation before returning to the field of immigration and nationality law. Before starting her own practice, Kristin gained valuable experience in employment and family-based immigration, removal defense, and employer sanctions litigation at a Denver law firm. She is the founding partner of Johnson Knudson LLC and its successor, her current firm, Knudson & Associates LLC. Kristin specializes in helping employers bring employees of extraordinary ability to the United States, advising and representing businesses on transferring workers to the U.S., and preparing petitions for investors and entrepreneurs. She provides high-quality, compassionate representation to families, victims of crime, and immigrants in removal proceedings. She speaks Spanish fluently and provides efficient, effective service to Spanish-speaking clients. She is also a former chapter chair of the Colorado Chapter of American Immigration Lawyers Association, AILA. She was from 2019 to 2020. She has also been a member of the executive committee of the Colorado chapter for several years of AILA. So we're quite lucky to have her here today, and we really think she's going to be able to provide some wonderful expertise to you all. Just before we get started, and I'll let Kristin take it here in a moment, there is a Q&A, question and answer tool here in the Zoom conference session. If any of you have questions that you would like to have answered live by Kristin, the attorney, at the end in the last half-hour Q&A portion of our webinar today, please add them to the Q&A. My ISSS colleagues, Amy Bello and Christine Wen, and I will be monitoring that throughout to try and collect them and organize them so Kristin can answer them live at the end. If it's a question that we think we might be able to answer given our expertise in ISSS, we'll do that. Otherwise, we'll collect them and post them to Kristin at the end to answer live. So thank you all again for attending today. And Kristin, I'll let you take it from here. Thanks.
Thanks, Tyler. I really appreciate the opportunity. I'd also like to thank Amy Bello with the International Student and Scholar Services. I'm really excited to be with you today. I think it's a really exciting time for a lot of you. Hopefully some of you are joining us very early in your career at the university so that you are preparing yourself for the next steps. There's a lot of planning that goes into deciding what you want to do with your future in the United States, whether you want to remain here, how long you want to stay in school. All of those things are really important to think about in advance. But I assume that many of you are also getting ready to graduate and looking at the next steps, looking for jobs in the United States. And so that's what I'm here to speak about today. So one of the things I hope you're thinking about as we go are, what are your goals for remaining in the United States? I think one of the things I always presume is that everyone wants to be here. As an immigration attorney, that's what people approach me about. But deciding whether you want to be here and how long you want to be here is an important consideration for you. So one of the predominant theme of today is the most common path after graduation. This is the way that most people do it. You graduate with a bachelor's degree or a master's degree or even a doctorate degree. You go through optional practical training. Some of you will be graduating in the STEM fields. You can get STEM optional practical training for an additional 2 years. You apply for an H-1B in a specialty application, and then your employer petitions for you to become a permanent resident. So this is the most common path, but I will say, given a lot of changes that we've seen in the past several years, a lot of our applicants, a lot of you graduating will need to be more creative than this. So you want to be open to other ideas and other paths and other possibilities. So we will also talk about other options for you. We've got temporary worker self-petitions. There are a few categories of non-immigrant status. When I say non-immigrant, I'm talking about temporary visas, temporary status in the United States. There are a few ways to petition for yourself. An e-visa is an example of that. We'll talk about that. There are other temporary options. Essentially, there are visas A to V, and many of them, we want to consider whether any of those could be opportunities for you. So we'll talk about some of those, touch upon them, and then just make note if you think that it's a possibility and you want to learn more about it. We'll talk about permanent residency. So permanent residency is your green card. It's your ability to live in the United States permanently as long as you don't make any mistakes and lose it. And there are a few ways to gain permanent residence in the US. So we'll talk about that. There are some humanitarian options that we'll go into briefly, like asylum, temporary protected status, U visas for victims of crime, and we'll talk about some family-based options as well. So I want to preface this whole presentation by saying that getting good immigration advice is essential. So this presentation is meant to be an introduction to immigration, supplemental to what you may already know about immigration and employment-based visas in the US, but this should not be the end of you conducting your own due diligence and research. Any path that you decide to take needs to be personalized, because anything from the prior statuses you've held in the United States, any immigration violations in your history, your travel history, your family, what country you were born in, what countries you're a citizen of, and any criminal history certainly can impact those options for you. I'd also like to note that when you're looking at immigration information, you need to be getting good information. Unauthorized practice of law, particularly by notarios, is a really big problem in Colorado and throughout the country. So, if you're not an attorney, you're not allowed to practice law. There are a few exceptions to that in some other states, but it's a pretty firm rule in Colorado. So make sure you're getting good advice, speaking to a real attorney. It will pay off in the end to get good advice and not necessarily cheap advice. You do have a right to represent yourself in any immigration application, but be cautious. Trying to save a few bucks on the front end can really end up being expensive. And if a mistake is made, it can draw out the process for years. You could miss an important deadline, or you lose the opportunity to remain in the US altogether. So if you're going to do it pro se, make sure you've been educated. And certainly this is a very complicated area of law. And so I wouldn't want you to miss out on any opportunities. If you're able to hire an attorney, especially once you get out of the university, that's the way that I would recommend going. One of the other considerations when you're talking about employment after school is whether you're relying on your employer's attorney. Okay, so you need to know when you're talking to your employer's attorney whether that attorney also represents you. And that can be a bit tricky. So I think the easiest thing to do if you're unsure is to ask. There are situations where the employer working on your case represents the company. So they're going to do what's in the company's best interest. You may not be informed of all the information. They're not doing necessarily what is best for you. Sometimes your interests are aligned and sometimes they're not. If you're not sure whether the attorney considers themselves to be representing you as well, you should ask. You know, if you found the attorney and you work for a small company, for example, and you then connect the attorney with the company, it's very likely that that attorney should be representing both of you. So then the attorney would have to do things that benefit you both. At the same time, if your interests are no longer aligned with the company, you quit, or the company lets you go, for example, the attorney would no longer be able to represent either of you in those related matters. Don't rely on your friends' situations, okay? And it's really important with all the information available online and at the university itself that you don't expect that your path will necessarily be exactly the same as your friend's situation. I'll just give you an example of this. You know, if you, for example, had a J1 visa in the past, you may be subject to something called the 2-year foreign residency requirement. You were probably able to get a student visa after having that J1, but you will not be able to get an H1B without spending 2 years in your home country. So you don't want to presume that your path is going to be exactly the same as someone else who's a student in school who didn't have a J1. And there are many different circumstances that can contribute to those types of different options and opportunities. Also important to watch your status violations. If you've done anything you're not supposed to do, worked when you're not supposed to work, didn't get the proper type of visa or enter on the proper type of visa, those are things that you want to fix sooner rather than later. Many times they can be fixed by traveling. If you wait too long, if you start misrepresenting information to try to get around those mistakes on applications, you could end up being permanently barred from the US. So if you had any issues, you should talk to an attorney about those issues before moving forward. So let's see. All right. So the typical path, right after graduation, you go to post-completion optional practical training, usually referred to as OPT. So this allows you to work for a year following graduation. It's going to be following your bachelor's degree and again following your master's degree. The work that you do after graduation needs to be directly related to your course of study. And the school is going to have to recommend you, so give you a new I-20 for OPT. You want to think about this early and you want to plan the timing. So I'm going to talk a little bit more about that. But this OPT is very broad. It gives you a wide variety of options for gaining experience after you graduate. You could have a traditional employment situation after you graduate where you've got an employer, you work on site with that employer full-time. That's traditional employment. Self-employment, you could start your own company in the year following school, or you could work as a contractor where you control your work hours, but you're performing work for various individuals, one company or more. You could do unpaid work or volunteer work as well. You could work for multiple employers. You can work part-time or full-time. You need to work at least 20 hours a week or be performing these related activities at least 20 hours per week to maintain your status during this time. So some of the timing, let's see. Hold on. Okay, so you must have an employment authorization card to work on OPT. this is important. It's not usually an issue. You know, the school gives good advice on OPT in my experience. CU does a great job of telling their employees or their students becoming employees of another company what they're supposed to be doing. However, I have run into issues where someone worked on OPT for years and never got employment authorization. So that would put that person out of status. So make sure you have that employment authorization card. You can't have more than 90 days of cumulative unemployment where you're not doing anything related to your degree during OPT, or you would be forced to go into your grace period and you would fall out of status after that. The 60-day grace period is given to you following OPT. You can't work during that time for a company, but you can remain in the United States. You could change your status at that time. You could look for other options to remain in the US. You could go back to school, for example. So you could, there are a lot of different things that you can do during that time. You wouldn't be allowed to work during that time. And as I mentioned, you have to update your I-20. So you need the initial approval from the school or recommendation to go into OPT. But you also need to update them if you're going to change companies during that time. So timing considerations for you, especially if you're planning on doing your own work. You're going to need to apply for employment authorization and get that recommendation on the I-20. So the I-20 recommendation needs to come first. So you need to talk to ISSS at CU, make sure you get that done, and then you can apply for employment authorization within 90 days of graduation, before graduation, or before your program completion, and up to 60 days after your program completion. You have to apply within 30 days of the school updating the CVIS with the OPT recommendation. And so I've seen that go badly, where it was 32 days after USCIS received the I-765 employment authorization application, that will be denied for not complying with the regulation. So it's very strict and you need to do it right. Otherwise, you end up getting a decision back from USCIS a lot of times outside of those, the 90 days of unemployment, for example. Your 12 months of OPT must be completed within 14 months of program completion. So when you look at the timing on this, you should apply early for your OPT or you won't get a full year of OPT. So you want to try to maximize that time. Another consideration that we're going to talk about a little bit more when we talk about H-1B is cap gap. So cap gap allows you, if your program ends after April 1st, or if your OPT is authorized after April 1st, then, and you apply for, your employer applies for an H-1B for you, then you're able to extend that employment authorization through September 30th, because October 1st will be the first day that you're able to apply or start working in the H-1B position. There are some benefits to graduating in December and starting your OPT early in the year. For example, it gives you more time to work with an employer before you're needing them to file that H-1B petition for you. So show them that you're worthwhile to petition for on that H-1B. If you're graduating in May, you finish your program in March or April, and you need that employer to file the H-1B registration, if that's the process that's in place, we'll talk about that further. On April 1st, for example, or March 1st, it can be difficult to get all that in place right on time, but the timing may work out better to give you multiple opportunities to apply for an H-1B. So it's a little bit complicated, but that can be part of the strategic planning that you do through information you receive from the school and through an attorney. All right, so let's see, let's move on here. We've got STEM OPT. So this is a much narrower type of OPT. STEM OPT is for only individuals with a STEM degree. It must be directly, the work must be directly related to that degree as well. The STEM OPT allows you to extend the 12 months and for an additional 2 years, an additional 24 months of employment authorization. You know, it can be an old degree that you rely on for STEM. So if you graduated from school with a bachelor's of science, but decided to go straight into getting your master's and you get an MBA, you could do OPT based on your MBA, and then you could use your Bachelor of Science degree to get an additional 2 years for STEM. Of course, the work that you're doing has to be related to the proper degree, and you need to meet all the other requirements. Typically, it's the same degree, but I did want to note that you can be a little bit creative here and use some of those old degrees, especially if you went straight through school. For STEM OPT, you need an employer-employee relationship. So when I spoke about, you know, being able to volunteer, being able to be self-employed, being able to be a contractor, for STEM OPT, they're looking for more of a traditional employer-employee relationship. Can't volunteer. The employer has to certify that they're paying you a salary that's commensurate with US workers. They do that so that essentially you're not working for super cheap and displacing US workers. So the employer has to certify that they're paying you something, a fair wage, something that they would pay any other worker with the same experience. The employer has to be enrolled with E-Verify, which is an online program that looks at your immigration status and everyone else's at the company. So they have to be willing to do quite a few things. You also have to complete and file a training program showing that the employer is training you in particular ways. That's part of the STEM OPT application, right? So it's a lot narrower, a lot more requirements, but you do get an extra 2 years. Timing considerations here, you do have to apply before OPT is over. So you can't wait, you don't get the 60 days after it ends to get STEM OPT. You have to file that I-765 before it ends. That means also getting the I-20 updated with the recommendation from the school. You can have a total of 150 days of unemployment throughout that OPT. And then you have to do 6-month check-ins. So you need to check in with your school every 6 months, and they need to essentially update the I-20 and let you know that everything is still good. And then there's a 60-day grace period. So when you're done with STEM OPT, you have 60 days again. You can't work during that time, but you are allowed to, you're given a little bit of breathing room to figure out what you're doing next and file any future application. Okay, so H-1B, the typical path, specialty occupation. So once you have a bachelor's degree, you're basically minimally qualified for H-1B. H-1B is basically for professionals in a specialized field. So H-1Bs are very much in flux right now. This was a difficult presentation to prepare for after many, many years of doing H-1Bs because there are many new proposed rules, there are interim rules, and it's unclear what this year is going to look like. Most of the H-1B applications, as we'll talk about, are filed during the CAP season. In April, last year we had to register all of those applications in March. And so it's unclear what it's going to look like, even though we're just a few months away. So I'll talk about some of those things as we go along. I'm going to try to focus on the rules that are in place right now because, rules, there's a lot that goes into changing rules. So that'll be my focus, but I will give you a heads up on some of the things that may change between now and then, some of the things that have changed but are subject to litigation. And as you know, we have a new president, or should have a new president as of January. Will that fix all of the things that have changed in H-1Bs that we don't like? I would say it's likely that President Biden will restore some of the H-1B program. But I think it's, historically, where there's high levels of unemployment, the trend is to try to restrict legal immigration, and restrict foreign workers' ability to fill positions that, may compete with US workers. So I can't say to what extent some of these new policies that are going to make it more difficult for you will be rolled back. We'll just have to see what President Biden actually does when in office. So these jobs typically require a bachelor's degree or the equivalent. They must be related to your degree. So you've got an employer who's going to petition for you. If you have a degree in electrical engineering, your job is probably going to be an electrical engineer. But there are some degrees that are not as closely related with the title of your diploma. So that is subject to litigation currently. How closely related does it need to be? And so that is one of the considerations we'll talk about a little more as we go on. But it does need to be related. So you're not looking for just any job that requires any bachelor's degree. We're looking for a job that's related to your specialized field that you graduated in. Let's see, so extensions. So the H-1B is you get a 3-year approval typically, and then you can extend to 6. And then sometimes there are further extensions of that H-1B. And the extensions would be based on the filing of an immigrant petition. So you've got this temporary H-1B, and now if you file an immigrant petition, or your employer does, more than a year before your 6 years are up, then you may be able to extend beyond that time. So, and then the other thing I wanted to mention here is that H-1B is dual intent. So a student visa, which many of you have, is considered a visa that requires non-immigrant intent. You have to prove that you are only coming to the US temporarily and you're going to return home at the end of that period. And you maintain those ties to your home country. Dual intent means that you could be coming temporarily or permanently, and USCIS, US Citizenship and Immigration Services, or a consular officer at the US consulate abroad, they're not supposed to ask. They're not supposed to look into what your intent is. And so that can be nice for a lot of situations where you're getting more established in the United States. Okay, so I mentioned the cap and cap gap. Let's talk about what the cap is. There are a limit in the number of H-1B visas in any given fiscal year. It's limited by Congress. So right now the cap sits at 65,000 regular cap and 20,000 US master's cap. If you received a US master's degree, then you have more opportunities to get an H-1B. There were only over 230,000 H-1Bs registered for the fiscal year 2021. So in March we registered. There were over 230,000 registrations filed for those numbers. So you can see that you have, less than a 1 in 3, usually a 1 in 4 or 1 in 5 chance of getting selected for an H-1B in a given year. So we'll talk about some other options in a little while, but essentially it's not a guarantee. Now, that would be if you're subject to the cap. Most private employers, many nonprofits, and many government positions are subject to the cap. You're cap exempt, meaning you're not subject to these limitations. If you're an institution of higher education, the employer is. If you're a related institution, that has a strict definition under immigration law. If you're a nonprofit research organization or a governmental research organization. So there are a very limited number of H-1Bs compared with the demand. It's historically the most common pathway for students graduating to gain temporary status and then eventually permanent status in the US, but you may need to look at other options. We'll talk about some strategies for that as we go on. All right. So I talked about the cap. If your employer that would like to petition for you is subject to the cap, then you have to go through whatever process U.S. Citizenship and Immigration Services defines for the given fiscal year. I say that because until this past fiscal year, this most recent fiscal year, the process was everyone applies on April 1st or the first week in April. You submit a full petition for the employee, and then they conduct a lottery after that. So, the employer was required to hire an attorney in most cases, prepare the full application, send off the full application with filing fees, and you don't know if the employee is going to be selected in the lottery and the case decided. And we got rejections back, just the full application back in the mail, but it took several months for that to happen. The most recent fiscal year 2021, I believe, is the 2020, it was in April of 2020. We had to submit registrations to an online system. So we submitted the registrations in March with a $10 fee, and then the lottery was conducted from there. I would say it actually ended up working pretty well, and it meant that most employers weren't required to prepare full petitions if they didn't actually get selected in the lottery. So there was a lottery performed, you were notified, go ahead and submit your petition within 90 days because you were selected in the lottery. And then if all this past year, the full number, 85,000 visas, were not taken through the lottery, so they did another round of selections. And so some individuals were notified later in the year that they could submit an H-1B petition. There's a new process that we may be looking at for this year, and it's a big maybe, because I think that this is likely to be something that Biden and Biden's administration is not fond of. But the new process would really select individuals that are competing for the highest proffered wage. So the employee is offering a high wage. Most of them will have master's degrees or higher, and individuals with offers for lower wages would be selected at the end. So this process would really make it a lot more difficult, honestly, for graduating individuals who have had OPT for just a year or even STEM OPT for 3, because you're competing with some of the more highly specialized individuals and companies that are willing to pay quite a bit more for the workers. So I don't know what's going to happen with this. I know that the university is on top of it and trying to put out good information for you. So I would first go there to get some good information. And we'll just have to see what happens, whether the process remains the same as last year or we get something completely new this year. So we got a few strategies that I'd like to talk about quickly because H-1Bs are so difficult to get nowadays. Avoiding the cap. So certainly if you can work for an institution of higher education in a field that's related or a job that's related to your field, then you won't have to deal with the cap process. You're not going to be applying on April 1st or registering on March 1st. The institution can apply for you at any time because there's no limit to the number of visas. You can also work part-time for a cap exempt institution and part-time for a cap subject institution. And if you do that, you are not subject to the cap for the cap subject institution, but you have to maintain that employment with the cap exempt institution. So that's another strategy for getting around it. If you're looking at 2 part-time positions, 1 cap subject, cap exempt, 1 cap exempt, you may be able to get around that cap requirement and the uncertainty there. If you want to improve your chances at getting an H-1B, apply early and apply in every year that you're able to apply. And so this is dependent on your employer wanting to do this for you. It's also going to be dependent on when you graduate and when your OPT expires. whether you can do that from the United States. All right, so you want to maximize your OPT and STEM OPT. Okay, so make sure you're applying early for OPT and you're meeting all of the requirements. Make sure you have STEM OPT lined up if you have a degree in any STEM field. You know, one of the ways that you can develop these relationships with employers in advance, it may be through curriculum practical training. You know, you may be able to do some kind of internship or work in advance of OPT. Just watch there is a way to disqualify yourself from OPT by doing too much CPT, so you need to watch that, talk to the school. But you want to create these relationships with employers so they feel like, I really want to commit to this worker. What can I do to keep this person working for me? So that can be difficult to do if you don't have a lot of time. You may want to try to develop those relationships without violating your status, of course, in advance. You can get a master's degree. There's additional visas available for individuals with master's degrees. You want to look, we'll talk about some considerations that play into the strength of an H-1B application. So you want to look for companies that essentially have a more straightforward path for you. And we'll talk about some considerations in a moment. And then there's a lot of uncertainty. So how do you deal with the uncertainty? If you know the employer is cap subject and going to file a petition for you, but you don't know if you're going to get selected, from there you need to come up with alternative options if your goal is to remain in the United States. Sometimes that means going back to school. Sometimes that means, hey, I'm going to start my own business. And I'm going to start my own business, and I know that there's a visa option available for me, like an E2 investor visa. And that's my goal, and that's my plan if I don't get selected in the H-1B lottery. You may have family-based options or any of the other options we're going to talk about later. So if you're dating a US citizen, it may be time to have a serious conversation about that and how badly you want to remain in the US with that individual. All right, so we're just going to talk about some considerations when looking at the strength of an H-1B petition prior to filing. So the wage offered. So I mentioned a new rule that may play into the selection of H-1Bs for higher wages. So certainly that's important. But even if that rule and the selection process does not go into an effect, a higher wage level is helpful for H-1Bs. There was a memo that came out a few years ago from US Citizenship and Immigration Services that said, you know, if it's an entry-level position, then it's possible that a bachelor's degree is not really needed for this. And we don't know if we're going to approve those entry-level wages. You can certainly, as attorneys, we fight back against that kind of weird presumption all of the time. When we respond, when we, prepare our legal briefs. But certainly if you have a company that's willing to pay you more and get you to a higher level wage, it's easier in some ways to show that it's a specialized position. The position title and description. So it's important that it's tailored to meet immigration's requirements. Immigration is going to be looking at a lot of things, so this may be a really important step to have done by an experienced attorney. The company typically will give me a position description that includes things like highly motivated, works well with others. And I would say that none of that stuff is relevant nor should be included in an immigration petition. The position title should be matched, or title and the requirements, the job duties should match closely with the federal classification that you want to match up with. And so that's something that an attorney can help do for you. So you want to make sure that if, anyone that is helping with this, if you're able to have a say in it, knows what they're doing with regard to position descriptions. The work site location. If you're working on site with your employer, then that's the easiest type of case to get approved. If you are being contracted out to people all over the country, you're going to have a difficult time, your employer will have a difficult time getting this H-1B approved for you. So that's another consideration, and that's because they're supposed to show that there's a valid employer-employee relationship. So those are some of the things to keep an eye on. The employer-employee relationship is defined by whether the employer, the person that is petitioning for you, can hire you and fire you, actually pays you, actually supervises you, or otherwise controls your work. So if you're being contracted out and your employer has no idea what you're doing on a day-to-day basis, that H-1B is going to be much more difficult to get approved. The company stability is important. More established companies, those petitions get approved quickly. Startup companies sometimes have a hard time showing that they're a real company. Sometimes they don't have the proper documentation. They haven't filed their tax returns like they're supposed to. So a more established company is going to be a better bet. And then when we get further along the line, looking at whether they can petition for you for your permanent residency, again, startups may have a more difficult time showing that they have the ability to pay you, which it plays into that type of petition. So long-term, a more stable, well-established company is a better bet. I know you don't always get to pick. You know, you don't always get to pick if you've only got one company that's willing to do this for you. But those are some of the considerations. When you're dealing with the HR representative, whether that be a supervisor or an actual HR person, are they responsive to you? Do they care about you? Do they really want you to work at the company? Are they transparent in telling you what they're working on? If they're not, it sometimes ends up being that they're not actually working on the petition. They just didn't tell you. They're not going to get it done in time, or they don't want to spend the money, but they don't want to tell you that either because you might leave. So these are some things to look for when you're dealing with the person that you have to approach about the H-1B petition and whether they're going to help you out. And will that employer commit to a perm labor certification process, the permanent residency process, down the road? Some companies take the position that they never do that for any employee. And so that's a big consideration for you. And do you have other options to become a permanent resident if you want to remain in the US? All right, so what is your role in the H-1B process? As I mentioned, this has to be sponsored by an employer, and it can't be self-employment. So you're not your own employer for an H-1B. So you're going to be asked to provide documentation of your status and your credentials, so your diploma and transcripts. You'll be asked to provide certain biographical information. It's important for you to follow up on important deadlines and kind of track the process, make sure that it's moving forward and know what's going on. If the attorney is providing dual representation, so you know that your best interests are being represented, the attorney should be communicating with you and CCing you on the communications. If it's not a dual representation, you need hopefully to be able to follow up with an HR person or a supervisor, but you may not get straight answers if you email the attorney directly, or that attorney is going to in turn send your communication to the employer. So you need to know what you're dealing with there. You may be asked to pay the premium processing fee for the H-1B petition. Currently, that fee sits at $2,500. If you want an answer very quickly within 15 business days on your H-1B petition, you can pay that fee, or the employer can pay that fee. You may need to post notice as part of this process. Posting notice, you may need to do that at home, and especially currently with the situation where many people are working from home that may not have in the past. Just to be safe, a lot of times the attorney will say, post this notice at all work locations, and if you're going to be working from home, they'll list your home and you need to post notice at home. And so you need to follow those instructions closely. Some attorneys take the position that it doesn't need to be done if it's at home because it's silly, and I would say that it is silly. I still have my workers do that anyway. And then if you have spouses or children who are dependents on your student status currently, for example, then you need to make sure that they are also filing petitions to change status so that their status mirrors yours at all times. So you may need to secure an outside attorney for that, or figure out whether the attorney that's filing the H-1B can handle the whole thing, but don't just presume that it's going to be taken care of for you. What is not your role in the H-1B? So making final decisions on the job description or the title, signing the petition for the company. You shouldn't be paying for the H-1B. So if your employer says, you pay for it, just tell me where to sign, it's not a good employer to work for, or you need to make sure that employer is educated. You need to understand your own status and the implications of the process that you're going through. All right. So if it's approved, your employer is supposed to give you a copy of the labor condition application. That's one of the first steps in the process for the employer. You want to keep your I-94s that indicate how long you're authorized to remain in the US and how long your status is authorized. Track your renewal dates. Make sure you know what to do when you travel, whether you need to obtain a separate visa or not. And if you're going to change jobs, you better plan in advance, because you're going to need a new company to file that petition for you before you decide to leave that old company typically. You could also get a request for additional evidence from the government. That's something the company should handle, but you may be asked to provide additional documentation. You could get a denial of your case, and then you have to figure out what to do next. Or sometimes they deny you the change of status. So you're not going to go from OPT to H-1B. You have to go travel abroad and get the actual H-1B visa, which is the travel document, return to the US, and now you're in an H-1B status. So those are all things that you might see. Okay, so let's talk about immigrant petitions. So the goal of an immigrant petition is to obtain permanent residency in the United States. Permanent residency is a permanent status. It's also necessary to be a permanent resident before becoming a US citizen. Most options, especially ones that if you're taking a traditional path after graduation, are employer sponsored, but not all. So let's talk about those different options. So the EB-1, employment-based first preference, has a certain number of visas allocated in a given year, and that's for extraordinary ability applicants, outstanding professors or researchers, or multinational managers. This is unlikely to apply to you, but we will talk a little more about it, and it may apply to you, especially if this is second career or you're a professional athlete, for example, or an amazing artist. EB-2, you need to have a master's degree or the equivalent, so that's a bachelor's plus 5 years of relevant experience. To fit into EB-2, there are less of these visas than EB-1 available, but more than EB-3. We'll talk about that. Or you have exceptional ability in a particular area. EB-3 are most professional workers. If you have a bachelor's degree, the job that you're looking at requires a bachelor's degree, then you're fitting into this EB-3 classification. Okay, and I'm showing you a screenshot of the visa bulletin. So you can see here, we've got that when I say EB-1, EB-2, you've got employment-based, first preference, second preference, third preference in the left-hand column. And then it's broken down by countries because the visa numbers are limited by country in a given year. If you see a C, that means that if you have all of the precursors completed, you can apply for permanent residency this month. If you see a date there, then you must have secured a priority date of that date or before to be able to apply in this month. When we're talking about permanent residency, let's go into the steps. And this is confusing, so if you have any questions or want me to go over it again, I'm definitely willing to show it to you and try to go through it a little bit more slowly, but we're starting to run short on time. So Employment-based petitions, most go through the PERM process, and this is a breakdown of the various steps. You have to request the prevailing wage from the government. This is the wage that the employer will be required to pay you at least based on the description for your job and the skills that are required. Once that's determined, then the company has to recruit for your position. They have to try to find a US worker through steps that are established by law. And if they find someone that is willing to work and qualified for the position, then they can't move forward with your PERM process. They don't have to hire that other person, but they also can't help you in the immediate future. The PERM labor certification is where you submit all the information about the job description, your experience, and the recruitment process to the Department of Labor. And they have to certify that, hey, there is an open position here. Once that position is certified to be open, then you file a petition for immigrant worker, the form I-140, and that qualifies you for the position. That shows that you meet all of the requirements to fill that open position. And the application for residency, once you have that I-140 petition approved, you can apply for your residency in a month where you have a current visa priority date. So that's the prior chart that I showed you. So, and sometimes you can apply if there's a current priority date, you can do Form I-140 at the same time as you file the Form I-485. All right, so again, your role in this, you're gonna provide proof of that you've maintained your status. You're going to document your credentials. You're going to have to get letters of experience showing that you meet each job requirement, that you'll actually qualify when we get to the I-140 stage. You want to track your dates, speak with HR or your supervisor, make sure your spouse and children are included on the I-140 petition, and that you file applications for residence for them when you file for yourself. You may be asked to pay for the application for residency. That's relatively common. You can definitely pay for that piece of it. You'll have to get a medical exam, and you will likely have an interview, although that's not always the case with US Citizenship and Immigration Services, where you're there to show you qualify for the position and are eligible for residency, but your employer doesn't appear at the same time. You cannot, however, participate in recruitment in any way. If you do, it will be invalid. They want the company to do a legitimate recruitment. You can't sign the PERM or I-140 on behalf of the company, and you shouldn't be paying for your PERM. It's prohibited by law. So if the company is asking you to do that or telling you we'll deduct it from your salary, don't worry about it. That's usually not allowed, okay? So you need to look into that and make sure that your rights are being represented well. It can also result in a denial of your petition if the government finds out that the employer was doing things it shouldn't. All right, so we've got employment-based second preference. We want to talk about ways to petition for yourself. So if you have an advanced degree or a bachelor's degree plus 5 years of experience, or you can meet criteria for exceptional ability, which is difficult to do right out of school, but the advanced degree or bachelor's degree plus 5 is a possibility for many individuals. And you're looking at performing work of national interest and substantial merit based on the government's definitions for those things, then you may be able to apply for yourself. It's called a national interest waiver. The waiver is a waiver of that PERM recruitment requirement. So you can file this national interest waiver for yourself, or the employer can file it for you. If you have a choice, you usually pick the employer to file it for you. But if you don't want to work for the employer for very long, you may want to file it for yourself. This is also a way to be self-employed or to move into self-employment. So, you know, I can talk more about these requirements if anyone has a question about it, but I'm going to move on because I think I'm running short on time. EB-1A, extraordinary ability. is for individuals who are considered at the very top of their field within a whole country or internationally, so at least in 2 countries. They want to see sustained national or international acclaim. So you've either won a major international award, a major national award, or you meet several requirements, like that you've judged the work of others in your field, like you've contributed something of significant merit to the field. So those are the things that you're going to have to prove for extraordinary ability. You're probably not going to be able to do it based on your own PhD work and thesis, but I've gotten extraordinary ability petitions approved for individuals as soon as 3 years after graduation. It's a very unique circumstance. Usually you're looking at a more, a longer career and numerous accomplishments to meet that requirement. EB-5 investors are individuals that have lots of money to invest in the US or are able to secure very large loans. There's also ways, so that would be starting your own business, or you could invest in another company that essentially gets all of its money from EB-5 investors. That's a way to gain your permanent residency as well. That could be a several-hour talk on its own. Other options, so TNs are for certain professions for individuals from Canada and Mexico. So we have free trade agreements, and the TN is for those individuals. Now, these are usually employer sponsored, but there's a category called management consultant that is, somewhere that we try to fit lots of people into as immigration lawyers, if it's even close, because there are only certain categories of work that are included in the free trade agreement. So accountants, for example, that's a classification. If you're an accountant, that is a free trade between Mexico and Canada classification. H-1B1 specialty occupation for Singapore and Chile. So we have free trade agreements with Singapore and Chile, and it's essentially an H-1B, but you don't have to file a petition. These can be filed directly at the US consulate. So they're fast track. There are typically enough visas available for these classifications. So if you happen to be lucky enough to be from Singapore or Chile, you may have an easier task ahead of you in getting an H-1B-like opportunity approved. E3s are very much like H-1Bs for Australians, similar to the H-1B one. You don't need an actual petition. You do need an employer to file that for you typically. E1s and E2s are treaty trader visas. So we have these agreements with certain countries for E1s and E2s, individuals who establish substantial trade between the US and their country, where they are a citizen, would be considered a treaty trader. And E2 treaty investors are individuals who invest a substantial amount of money in the United States to establish their own business. There are also certain categories that allow for employees from those same countries. So this may be a self-petitioning opportunity if you're from a country that allows for, that has that treaty in place with the US. Other options, you could return to school as a student and continue your studies. O1 is an extraordinary ability or distinguished reputation in the arts. So again, maybe you have, kind of a side career or a prior career that would allow you to apply for something like this. P1s are internationally recognized athletes, professional athletes, or entertainment groups that would meet that level of international recognition. L visas, L visas are for intra-company transferees, so you're transferring from abroad to the US. So initially it sounds like something that might not work, but if you are applying to work at a company that has branches abroad, then you may be able to ask to be, positioned or stationed in the UK for a year or 2 years and then transferred back to the US. And you can do that to fill a managerial or an executive position, or one that requires specialized knowledge. So that's another strategy. Perhaps a year or two abroad will get you a more permanent pathway within the US through an L visa. Humanitarian options. If you're afraid to go home, you're afraid of being persecuted for your religion or because of your race, this is something that you may want to consider. Asylum is an option that is available to anyone who fears persecution. You're supposed to apply within a year of arriving to the US, but if you're in lawful status, you just need to apply within a reasonable amount of time of losing that status. I would say that asylum's been under attack by the Trump administration. It's gotten more difficult to get asylum, but I think one of the things that the Biden administration has promised is that they're going to walk back many of those policies, and most of them are just policies. There really haven't been any new asylum laws passed, so they should be relatively easy. You know, those things could be changed on day one, many of them, not all of them, but some of them. So we may see a return to a more reasonable asylum system, something to talk to an attorney about. It'd be better to talk to someone about it if you're thinking about that before you graduate, so that you make sure you don't fall out of status. U visa are for victims of crime. If you've been a victim of crime in the United States, you may want to talk to an attorney about whether this is an option for you. T visas are for victims of human trafficking. Again, victims of crimes where you, sometimes this is even in the workforce. If you had an employer that took your documents from you and forced you to work against your will and you were threatened, then you may have actually been a victim of human trafficking, and you may have other opportunities here. So this is more common than it sounds. VAWA, if you're married to an abusive US citizen or a resident, or an abusive parent, or a child, so you're the parent of a child who's abusive towards you, then you may be able to petition under VAWA for residency by yourself and not rely on your spouse. It's typically spouse, but not always. Family-based options. This is one that we see a lot. I hear, you know, I have a couple come into my office and, you know, say that I want to pursue an H-1B through my company. How do I go about getting my company to do this for me? And then I stop and say, well, who's this other person with you? Well, this is my fiance, but we don't want to do it through marriage. We want our marriage to only be about love and marriage and not about immigration. I want to do it on my own. And I understand that sentiment. However, family-based options can be very straightforward compared with a lot of these other options we've been discussing. So you need to be looking at if we're talking spouses, we need to be looking at a real bona fide marriage. You're marrying for the purpose of being together forever, right? You're marrying for the purpose of sharing a life together. But a lot of times the practical immigration considerations weigh on that decision, and that's okay. So there are other relationships that qualify. So if you talk to any attorney, you know, about your immigration options, they should be asking about those other relationships. All right, so some takeaways from a very fast run through of a very complicated area of law, and something that's very important to most of you, I would expect. Take full advantage of the resources that CU has to offer. They've got some excellent people over there. Amy has a ton of experience. I knew Tyler when he was in private practice, Tyler Stokes. He's awesome. So definitely take advantage of those resources. And just the page I was checking out, the web page, they're up to date and they're posting great information for you. So make sure you're taking advantage of the resources at CU. Research early, and many of you are off to a great start on that one by attending the presentation. Explore your options with an open mind. You know, don't expect to get the job at the university that will make you CAP exempt and not have any backup options, okay? Because, you know, if it doesn't work out, you could be on your way home, and then trying to get a position in the US from abroad It can be very difficult, it could be expensive. So make sure that you explore all of your options with an open mind. Get personalized legal advice. As we talked about, very important to know what your options are, not your friend's options. And you want to work flexibility and alternate options into your plans to deal with the uncertainty that exists in today's immigration law. So here's some resources for you. We've got your own CU International Student and Scholar Studies link, the American Immigration Lawyers Association. There are lawyers in every state across the country. There are lawyers internationally. These tend to be lawyers that are up to date on what's going on. They're not all wonderful, but you have a better shot if you go through this AILA Find a Lawyer search than if you just, drive down Federal and hope to find a good notarial. These tend to be more reputable individuals. U.S. Citizenship and Immigration Services has a website. There is a lot of information on there. The website's not as helpful as it used to be, but it is, you can still search on the website to find information. And this is your source for forms. Never pay for an immigration form. You might have to pay to file it, but you shouldn't pay to get it off the internet. So if someone's asking you to pay after you filled out a form, it's not the right link, most likely. This is the right place. The uscis.gov is the right link to get your forms. All right, so my contact information is here. You're welcome to reach out to me with questions. And that's my contact information. If you want an individualized analysis, then we would want to schedule a consultation. Okay, so I'm open for questions at this point, and thanks, Tyler, for your patience with me as I ran over a few minutes.
No problem at all, Kristin. Thank you so much. It was a really fantastic presentation. We really appreciate your time today.
No problem.
So yeah, I do have some questions. There's not a ton. We still have about between 30 and 40 people here in attendance. So I'll just kind of go through. A lot of them I think are related to H-1B. Let's see. So one of the first ones we had was, is the highest wage dependent, I think they're referring to the H-1B for prevailing wage, is the highest wage dependent on the country we are working in or the country we will be living in? Sounds like they might be confused about H-1B. Also, is there a website where I can check the minimum wages needed to qualify for H-1B?
Okay, so when we're talking about an H-1B position, that is to work in the United States. If you're going to be working and physically located in another company, or in another country, you don't need an H-1B to do that. So that would be to live and work in the US. There is a website that allows you to look at there are websites, I would say, that allow you to look at federal classifications. So one is called ONET. So you can look through ONET, O-N-E-T, and look for, there's a number associated with different types of jobs, and you want to try to match up the job duties with what you'll actually be doing. That's kind of the way we start in researching a position, to see what the government says this job looks like, what are normal titles for this job. And then you can match it up by going to the Department of Labor website with the prevailing wages. A new prevailing wage rule came through very recently and dramatically increased a lot of those prevailing wages. And that's something that is being litigated right now, and I'm not sure what it's going to look like. But in addition to these rules that may give preference to jobs that offer higher wages, the actual wages that the employers are required to pay may be substantially higher this year than in the past. I can look for those links, or maybe one of you can pull up those website links.
Yeah, we're posting them in the chat now. But I messed up on part of that question. The first question was actually, is the highest wage dependent on the county we are working in or the county we're living in, not country? I misread it.
Well, I think the way the new rule is laid out, and I hope I'm not speaking incorrectly here, but they're looking at the actual literal highest wage that's being offered to the employee. If you're looking at the prevailing wage, so what an employer is going to have to pay at a minimum to the employee to work in a particular job, that is county dependent.
I think it tends to be like sort of statistical area, so it might include multiple counties.
Yeah, exactly. It's the metropolitan statistical area.
Hmm.
So, but you'll see like for Colorado, it'll be Denver, Adams, Aurora, I think, right? So
Yeah,
it's the
Arapahoe.
whole Denver metropolitan area that is grouped together. And I think
Mhm.
even Boulder, no, Boulder's separate, I think.
It depends. I
So
mean, that we use that prevailing wage area a lot for people that work at our university.
yeah, well, that makes sense.
Um,
So
oh, go ahead.
go ahead.
Um, this person asks, what I think they're also referring to H-1B. So trying to work for H-1B through a university. They're saying, what kind of job in a university, a professor or a researcher, and is a community college a valid option to avoid the cap?
So if it's an institution of higher education, and it's a nonprofit, I believe. So that's where the community colleges sometimes don't qualify. So it depends on who it's run by and how it's established, how it's set up, whether it's going to qualify. The positions, they have to be H-1B positions, right, to qualify, but it doesn't matter what H-1B position you're looking at an institution of higher education, they would qualify for, if they're an H-1B position properly, then, you would be cap exempt by working at that institution.
Yeah, and I think Gustavo asked that question, but Gustavo, at least at our university, that tends to be like postdoctoral researchers, professors, things like that, most often. This question asks, are there any regulations or restrictions against pursuing a formal education, as an example, a master's degree in the evening or online, while being employed full-time on H-1B? So I guess you can answer that one first, and then I'll pose the other one.
Yeah, you can continue to study while on an H-1B, but you couldn't work for an employer that's not authorized as an H-1B employer.
The other question this person asked is, what higher education accreditation do we need to verify that a master's degree meets the requirements for the additional cap for the H-1B lottery? Does that make sense?
Yeah, so you do have to have a master's degree from an accredited US institution, and they just have to meet the requirements under a section of the US code. I think it's 1001A or something like that of the US code. So if you have a master's degree, that's something that you should look at, or preferably the attorney looks at very carefully to make sure that they're including evidence in your master's cap petition that whatever institution you got it from meets those requirements. Mm-hmm. Because if they don't believe that, if you file the H-1B under master's cap and you haven't included proof, or it's not clearly one that qualifies for the master's cap exception, then you could be rejected, and they're not going to consider you for the bachelor's degree regular cap at that point.
This next student, Sanesh, asks, I graduated in May 2020 and I have a full-time job at the state of Colorado. I'm on F1 OPT and wanted to know the rules and regulations for a work visa. For state government jobs, are the rules for visas different? What are the types of visas I might be eligible for? So for working for the state.
Yeah, so many of the opportunities are going to be similar through the state, and it'll depend on what kind of institution, what state agency you're working for. So some of the state, if it's a state research institution that qualifies as such, then you might be exempt, but probably not. So they're still going to have to apply for an H-1B for you, just like a private employer would.
So working for a government employer or a government office or agency doesn't necessarily mean that you can avoid the cap. Is that the basic?
That's true.
Okay.
Same with working on government contracts. If the company's a private company, but they do government contract work, you're still subject to the cap most likely.
Right. Harshit asks, I will be graduating in May 2021. So the earliest I can apply for H-1B through my company would be March 2022, or can I still apply in 2021 anyhow? So it's more of a timing, I think.
All right. So an employer can petition for you. Well, first of all, you need to have all program requirements completed at the time you apply for an H-1B, or the company petitions for you on an H-1B. If you don't have a bachelor's degree, you're probably not going to qualify for that H-1B to begin with. So when you apply, you've got to have your program prerequisites completed.
This
Okay.
student would be graduating with, I believe, a master's in May 2021.
Okay.
Before he has the degree.
Okay, so if you've got a bachelor's degree and you have a company that wants to petition for you before you graduate with your master's, that's fine. That would be great. Apply early and often is what I say.
This student asks, this is a Sanesh again, asking, is the wage criteria there for government jobs for H-1B? I'm not sure if you know what he's asking.
For government jobs, maybe they also have to meet the wage requirements for H-1B.
Mm-hmm.
Yes.
Yeah. This is just a question we may be able to answer, but Adriana is asking, can I be denied for OPT or STEM OPT under any circumstances? I think yes. The answer is yes, Adriana. I'll let Kristin give her take on this, but what we usually tell students is that for the most part, we obviously, it's the government's decision and it's your application. So we give you guidance about how you apply and what you need to include and things like that. Based on current information we have from the government, we try and make their instructions easier to understand. But ultimately, it's your responsibility to make sure you include all the information you do, make sure all your information in your application and documentation is complete and accurate. But ultimately, I would say that we can't guarantee that it would be approved, but we usually only see students denied for OPT or STEM OPT if they failed to follow instructions, if they used an electronic signature on their application form. It's usually technicality things. They didn't include something or didn't say something they were supposed to. It's usually not because the government just denies them for no reason. Like it's usually like they failed to follow instructions or something. The other times when we don't see that, it's pretty rare. But it's always good to check in with us about that. I don't know if you had anything else to add, Kristin.
I would say there's no certainty. So as much as I'm encouraging you on any type of application that you file with the government, the greatest certainty is when you have someone prepare it that knows what they're doing and that they're really on top of what they're doing, and you provide them with what they need to apply. That's going to give you the best chance. But I think, a lot of people come to me asking for certainty. Am I sure that I'm going to get approved? And I always say no. There's no certainty in immigration, but you can improve your chances by doing things right. OPT is one of those things that a lot of times students do on their own with guidance from the university. But I've also had individuals that were just nervous about completing the process themselves and wanted someone to walk them through applying for employment authorization. And so I prepare those applications for them and make sure that we do it right.
Yeah, and that's a good point. We always try and tell students this, but with your I-765 form for the OPT application, or preparing the documents that we talk to you about, or the STEM extension application, ISSS is always the first group to stand up and say, we highly recommend that if you have any concerns about your individual application, that you consider having an attorney review it with you, maybe file it on your behalf. There are pages where an attorney preparer can sign as the preparer and put the application together for you. So we always think that's worth considering. Adriana also asked, and Adriana, I think I can answer this, but is there a way you can be denied OPT? I think we answered that already. Is it based on salary? What if it's a small LLC? So I don't know if you've been to the OPT work clinic, Adriana, but you don't need a job to apply for OPT. It's different from curricular practical training, where you do need a job to get approved by ISSS for that. When you're applying for OPT with USCIS, the government agency, you don't need a position already to apply. You have to get a job after you're approved. So the salary and LLC questions aren't really relevant to that. But if you need to follow up with me directly, just make an appointment with me and we can talk further about that after you've gone to the clinic. This student is asking, will we be getting the slide deck for the presentation? So this presentation's been recorded, so we're going to make that available to you all as soon as we can. This student's wanting to know, Kristin, what is your consultation fee?
Oh, well, so we typically charge currently $200 for a consult, and you'll find attorneys that charge anywhere from free to quite a bit more than what I charge.
Right.
So,
they can find more information on your website as well.
exactly. Yep.
This one, we got about 10 minutes left. This student is asking, I currently work at the CU Anschutz Medical Campus and mailed in my application for STEM OPT last month. I got my receipt notice already. When is a good time to talk to my employer about H-1B? And what if I think the cost is too high and want to contribute to my application fee, I guess? Is it illegal? So paying for fees or helping cover the cost of the H-1B for the employer.
Well, you have to use your discretion in when you're going to talk to your employer. So this is actually CU though, right? Like you probably want to.
No, I think talking about, it doesn't sound, it sounds like they're working for a private employer.
Okay.
Well, no, I think they'd be working for the Anschutz Medical Campus. It looks like.
Oh, okay. I must have misread that. Thanks, Amy.
Okay.
Yeah, yeah. And so I would just chime in on this, that our policy is typically, we can start filing an H-1B up to 6 months prior to the start date. So if I believe that this person was on maybe OPT or STEM OPT.
They're applying, they have pending STEM OPT now.
Pending STEM, okay. So I would say it's really up to the employee and employer as to when we would file the H-1B petition on your behalf. But, you know, it's really going to be a conversation about, first of all, you know, what the need would be around filing for the H-1B, perhaps at this time versus later. And we would look into all of that. So I would say, you know, if you're interested in an H-1B, feel free to have that conversation with your employer, but be aware that it is the employer's application. And so they would kind of make the determination as to when that application should be filed. But yeah.
Right, and you can always follow up with Amy as well if you have any other questions.
Sorry, Kristin.
No, so that's
I
actually,
wanted you to jump in because I thought it was CU policy there.
No, yeah, I'm glad you caught that. I misread. So we have about everybody who's still in attendance. We have about 8 minutes here with Kristin, and I don't have any other questions on deck for the Q&A. So if anybody has any other questions they'd like for Kristin to answer live here with us, feel free to post them in the Q&A.
Hey, Tyler, I don't know if anyone answered the second part of that question about the cost is too high and if I want to contribute to the application.
Yeah. Go ahead, Kristin. Yeah.
The law prohibits you from contributing to the attorney's fees or the actual filing fees, except for premium processing on an H-1B. That's the simple answer. So yeah, I think the concern is always that it's going to be too big of an imposition on the employer, and like, why don't I just help out? But that actually puts your whole application process and your life in the U.S. kind of in a tentative, precarious position to start going down that road. So really, hopefully you provide a substantial benefit to your employer so they're willing to invest a little bit up front. Your employer can do things like include some sort of liquidated damages clause. So say that if you were to leave the company too soon after getting your H-1B, that you have to pay them a certain amount. But you have to watch whether that would take you below the prevailing wage and a few other things. So it's pretty complicated beyond the simple rule of no, that you shouldn't be paying for this.
Yeah, so I think the takeaway from what Kristin just said here about that is just don't assume that it's okay, or if there's any kind of special circumstance where you may potentially be contributing some of the costs, especially if it's a private employer, it's probably best to at least run that by an immigration attorney through a consult before you make assumptions. Another question popped up, Kristin. Does the Will intra-company visa sponsorship have dual intent for a path to citizenship? And how long is it valid for, and is it renewable?
So we're talking about the L1 intercompany transfer.
Yeah, L intra-company transfer visa.
Yeah, so Ls are dual intent, and there's another classification, EB1C, so employment-based first preference classification, that's very similar to the requirements for transferring managers and executives to the US. So if you are a manager or executive, then you can pretty easily go from an L1 to permanent residence through that path. You could also go like L1 specialized knowledge, and then the company could file the perm labor certification for you, and the application for an immigrant worker. So the typical perm I-140 residency process.
So I guess it's somewhat similar to H-1B in that respect.
It's similar to H-1B in, yeah, that you could do that process and you wouldn't have to worry about travel to and from the US during the pendency of a petition for residency during the I-140 stage.
Right.
When you file an I-140, or the company files an I-140 for you, it's some indication that you want to live in the US permanently. So it can cause problems if you're in a status that doesn't have that dual intent built in. So you have to be very careful about how you do that.
Okay. And how long, as the second part to this, how long is an L1 or an L visa valid, and is it renewable?
L1s are valid for 5 years if you're specialized knowledge. Well, it's 3 years and then an additional 2 years. Or it could be up to 7 years for for L1A. I got distracted.
Getting into the weeds.
Yeah, exactly.
So we don't have any other questions on deck. If anybody else has any other questions, feel free to post them now, and I'll pose them to Kristin. We have about 3 or 4 minutes left, so maybe we have time for 1 or 2 more, depending, if anybody has anything else. While we're waiting, I don't know if you have any other final thoughts or anything, Kristin, or Amy and Christine. I don't know if you had any questions you wanted to pose.
I do not. Yeah, sorry, go ahead, Christine.
Oh, I was just saying, no, I don't have any additional questions, but thank you, Kristin, for the great presentation, and thanks, Tyler, for moderating the questions.
Yes, I echo the same. Yeah, thank you so much, Kristin.
Thank you. It was a pleasure.
Yeah, it's been nice having you. I think this was extremely informative, and I think it's going to be a good resource to post for the students.
Great, I hope so. If anyone has any follow-up questions, feel free to reach out. And like I said, if it's, really specific situations, then we definitely should sit down and go through everything, your full history.
It looks like we had another one pop up from Kongwei Chen. She said, can I apply for H-1B multiple times each year?
Ah, okay. So the same employer or any type of related employer can only file one petition for you. And if the employer files more than one for you, they're going to get caught and all of them will be invalid. If you have different employers that are completely unrelated, then they could each file a petition for you.
And I suppose maybe what Kongwei is getting at is that, so at the normal filing time in March, April, every fiscal year, your employer maybe files for you once, and then you don't get picked through the online portion for the diversity lottery, and then they try and file for you again or do another online submission. I think maybe that's
it. Okay.
I'm just I'm not sure exactly. I think that might be what she's getting at. Like, can they file multiple times or attempt to give you multiple chances, I guess?
Well, so like I said, you don't want them to apply for you under the regular cap and the master's cap, for example, because they'll both of those will be voided for filing 2 applications for the same position or in the same company, essentially. If you miss the deadlines, if this is cap subject and you miss the deadline for registration or for filing the petition, then you're out of luck for a full fiscal year until the next year. So if you have two companies that both want to sponsor you, then you need to have those registrations in March. If that's the deadline for this year, we'll just have to see what that looks like. You have to have them in by the deadline in March, or you won't be considered. If it's CAP exempt, then you can do it at any point during the year. So you may find out that you weren't selected for an H-1B position and then get a job offer at an institution of higher education, and now you can apply at any time. It gets more complicated if the question is, we need to look at maintenance of your status during any time frame that you're looking for work. Are you still an OPT? Are you in your grace period? You need to make sure that you're maintaining your status, or that you leave at the appropriate time so that you don't run into issues with that. I didn't go into it in too much detail, but the status that you have in the US is within the United States, and applying for changes of status, extensions of status, that's a little different from the visa. The visa is the travel document that you get abroad. At the US Embassy or the US Consulate, they'll put it in your passport, and when you enter the United States, you're now in the status indicated on the visa that you use to enter the country. So you see those terms status and visa thrown around, but they are two different things, and applying for a visa is an additional step many times to then enter the US and have a particular status.
Yeah, we have in our roles, we have that conversation a lot in our office about, we have a lot of students that change from H4 to F1, and we tend to give them to attorneys ultimately in the visa versus status. But I think that's all the time we have today, Kristin, but we want to thank you so much again. It's been really informative and very helpful, and I think the students and our employees got a lot out of it who attended today. So thanks again.
Great, thanks so much.
All right, take care, everybody. Like I said, we'll try and post this and make it available to you all, the recording of today's presentation, as soon as we can. Thanks again for attending, and have a great rest of your week. Thanks.
Thank you, everyone.
Take care.